Hi, I'm Jerry Sparks, President of AG Financial Insurance Solutions, and we have again with us the renowned Rich Hammer, premier church law attorney in the nation, as far as I'm concerned.
Okay.
So we're here again, and if you have questions in regards to anything we're talking about, feel free to email us or at the bottom of the screen, just ask us a question. Also, if you have topics that you want us to discuss sometime, go ahead and just put that at the bottom of the screen and get that to us also. So today we're going to pick up kind of where we left off last time, but we're going to talk a little bit about, start off with employment practices liability and what we're seeing in employment practices liability. And churches normally don't even think about employment practices liability because they're a religious institution, and how can they get sued for something that happens with employment practices liability? But why don't you kind of just mention what kind of lawsuits that we're seeing with employment practices liability and why churches should have that coverage?
That is such a good question, Jerry, because as you know, I review all litigation in this country, all 50 state courts, all federal courts pertaining to religious organizations. Why are churches in court? And my study over the last several years has shown that if you look at categories of liability, and these are broad baskets that contain numerous elements. For example, when I look at employment practices, there are about 27 things that I track. All different kinds of discrimination under state and federal laws, wrongful dismissal, etc. And it turns out that has been consistently third place among the categories of liability impacting churches over the last several years. So the point is, this is a very significant type of liability. And when it happens, you terminate a custodian who sues you for disability discrimination. You turn it over to your insurance agent, and you get a no coverage letter, meaning a letter that says, thank you, but this claim is not covered under your church liability policy. Look at the exclusions at the end of the policy, and employment practices is one of the first exclusions that's mentioned. And so, to the horror of the church leadership, you realize this is an uninsured, potentially substantial risk. And so that is a major, I like to put it this way, it's a major gap in insurance coverage for most churches in this country today. It's something they don't think about because insurance is not an intentional, rational process where you have an insurance committee of informed people that look at the options and make sure you have proper coverage, study the exclusions, make sure you're covering those. So, for example, for employment practices, all it takes is a separate rider or endorsement on your policy to extend your coverage to this area of liability, and it's generally not that expensive.
It's actually really reasonable, and most of the time they add it to the directors and officers liability. You can do a $1 million policy, where most people don't realize it is really the defense cost that comes into play because normally it is a government agency like the EEOC that is coming in there and bringing the lawsuit because somebody has contacted them. Mm-hmm. So whether you're a church, where we see actually have seen lawsuits and employment practices liability, I will tell you probably 5 years ago we saw very few lawsuits, but they have just been growing exponentially over the years, including up to this year. But where we really see it happening is age discrimination and sexual discrimination. We're going to replace an older pastor with a younger pastor. We're not promoting a female pastor. When we see this sort of thing happening, that's where we see actually the employment practices liability happening.
And Jerry, let me say this. When you're talking those two cases you just mentioned, replacing an older pastor with a younger pastor or a female with a male, when you're dealing with ministers, churches are protected by something called the ministerial exception that was affirmed unanimously by the United States Supreme Court last year. And what that rule says is this. The First Amendment guarantee of religious freedom, whatever it means that the civil courts cannot resolve disputes between churches and ministers. So that is dead on arrival. That's not to say somebody can't file a lawsuit against a church for age discrimination or gender discrimination involving a ministerial position, but that case is never going to get before a jury. It'll be dismissed. But then all the other non-minister staff the ministerial exception doesn't apply. It doesn't apply to church employees generally. It's only ministerial employees, which are generally a small number compared to the total number of church employees. So, but you're right, age discrimination, gender discrimination, and one area, Jerry, that I see a lot under gender discrimination has to do with churches that want to uphold their moral standards, their membership standards with respect to their employees. Sometimes they specifically have employment standards. So here's a typical case. You have a church operates a preschool, and you find out that a 20-year-old female worker in the preschool is pregnant out of wedlock. She's not married. And so the church immediately terminates her. Well, she finds out that you had a male youth pastor that was guilty of extramarital sexual relations a few years ago, and you just slapped him on the hand and said, hey, don't do that again, and retained him in his position. That is discriminatory. And the courts have clearly said you can enforce your moral or scriptural standards. That's fine, but you've got to do so consistently. And so in the case I just mentioned, that church is subject to liability for gender-based discrimination. They treated a male more favorably than they did a female. So with regard to moral standards, be sure that you enforce your employment standards on a consistent basis. Again, be sure you review your insurance coverage to see if you have employment practices. Because even if you may win the case, you have the cost of providing a legal defense.
And again, most of the time it's the EEOC, so you're dealing with a government that is bringing the questions to answer, and it's hard to defend against the government. So that's a good point. Let's talk a little bit about workers' compensation and what it covers. You know, most churches can't survive without the pastor, and
Jerry, before you get to that, could I mention something about workers' comp? There was a study done a few years ago, I remember reading, by a major publication, and it indicated that it was close to 70% of pastors thought that churches were exempt from workers' compensation law.
Wow.
And so they didn't have any coverage. Talk about that.
Well, when you look at workers' compensation,
our church is covered by workers' comp. That's the question.
Well, yeah, they are covered if you buy the coverage. And
what if they don't buy insurance? What if they say our church is exempt from workers' comp? We don't need that.
Well, then I'm going to basically, here's what's going to happen. When you look at workers' compensation, okay, a lot of churches have one employee, the pastor, and he may be bivocational. If anything happens to that pastor, that church closes. Okay, what better way to protect that church than to buy work comp, which is covering that pastor? And what does that cover? It's going to cover his medical bills. It's going to cover him while he is disabled till he can get back on his feet. And the coverage cost is so minimal for work comp on a pastor. And I'm talking all 50 states have a very, very low rate for pastors. Now, when you get into people that may be doing the grounds work and stuff like that, you're going to end up with a little bit higher rate. But for pastors, the rate is so low.
Because they normally don't get injured on the job.
They don't. And but when they do get injured, they're looking at something. And unfortunately, a lot of our pastors do not have health insurance. So work comp is almost a necessity.
Well, talk about this. What about a church that has, let's say, an office secretary or bookkeeper or custodian injured on the job, and they decided we're not going to get workers' comp insurance because we're exempt, and they're not.
And they're not. Actually, they can be held liable then for all the damages. Not only that, they can be penalized because they were supposed to have work comp and they did not have work comp. The protections of work comp actually protect the company or the church, the corporation, from actually being sued by that employee. If they did not have the coverage, they're subject to the law. They're subject to suit. And actually, the government's going to throw it to them a lot worse because they did come under the law and they did not abide by the law.
And not only are they subject to suit, but that's an uninsured risk. Because again, you look at the policy, your insurance policy, one of the first exclusions is injuries to employees in the course of their employment because of the assumption you've got workers' comp.
Right.
So if you say, well, we're exempt from that, you're incurring a potentially astronomical uninsured risk.
one of the other things that a lot of people don't think about is, oh, you've only got me as a pastor, so I'm not too worried about it. But they hire Joe the landscaper to come in and do landscaping. And the way the laws read in most states is that subcontractors, if you do not get a certificate of insurance from a subcontractor, you're responsible as actually being the general contractor of those people, even though you're a church. And we've had this actually happen where, a landscaper, you may say, I'm the boss of the landscaping company, but I hire somebody else underneath me, and I don't have work comp coverage, but I'm not going to sue the church. But it's the employee that gets hurt, and he ends up suing the church, and he ends up winning.
Yes, and also we need to address the whole issue of who is an employee subject to the workers' comp law. And that term, is, as you point out, is defined very broadly to include people that many church leaders would not even think of as being employees.
Absolutely, absolutely. And that it is, work comp is so set up to really not only protect the church, but is really set up, in my opinion, to benefit the employees.
That's right.
And who is covered under employee, because they want, it is not fair for someone to get hurt on the job or technically get hurt and not have coverage. And the courts have always realized that, and they are very favorable to the employee in all the court systems.
And the whole notion of an injury on the job has really evolved over the years. In recent years, one of the hot areas in workers' compensation litigation has to do with stress-related health problems, including heart attacks. Well, that was caused by my job because of the stress of the job. And there's been a lot of litigation on that point. So that's the kind of potential injury as that definition has been expanded in recent years.
In the state of California, they actually try to say a heart attack would be covered under work comp. Every other state, Missouri, has kind of stayed away from that. But, things start at the east and west and kind of work their way in. Let's talk about traveling across state lines. You're going to go on a missions trip.
Or national lines.
Or national lines.
Yeah.
Okay, well, let's start with state lines. Most people don't realize that I buy work comp. I'm in Missouri, so I'm going to buy work comp in the state of Missouri. There's a little endorsement you need to make sure that's added to your policy called the All Other States endorsement. So what happens is if you travel across state lines, like to the state of Illinois, because we're going to go visit Chicago.
From Missouri.
From Missouri. Illinois' benefits are about 3 times that of the state of Missouri. I get hurt while I'm up on that trip in Illinois, and I get an attorney. He's going to say, we want Illinois benefits. We don't want Missouri benefits. You need to have that all other states endorsement onto your policy to make sure that you're going to pick up those extra benefits while you're traveling across state lines.
That's a good point.
So also, if you're located in the state of Washington or Ohio, those are called monopolistic states. And basically, you have to buy insurance from the state itself. And so you have to be careful what state you're in, because you may not always be able to get work comp through a regular insurance carrier. So if you have employees, a lot of times I'll see people that say, I had a church call me the other day, and they're in Connecticut. And if you're listening out there, see, I'm talking about you. They're getting ready to open up a church in Washington. And I said, you've got to buy work comp through the state of Washington. And he said, no, we've got our, I'm in Connecticut. And I said, yeah, but you're located in Washington. You need to buy the insurance in Washington. And you have to be very, very careful, because certain states, before you start that operation and before you get that first paycheck, if you do not have the work comp in place, okay, the penalties are like $1,000 a day. And believe me, that they're looking at that as a revenue maker for for those states. They're looking for any way they can get revenue, and you have to be very, very careful with that. So let's talk a little bit about going across the national lines now. Foreign coverage. Where are you seeing? We're talking a little bit about work comp. We got repatriation. Standard work comp carrier will not cover it if it's across national lines. How do we get repatriation coverage? Where do you see claims coming in as far as foreign liability?
Well, Jerry, so many churches will send groups of members to a foreign country for what you might call a short-term missions trip, maybe to Mexico, maybe to Central, South America, sometimes Africa or Asia. And I know that I've dealt with some of these cases. I'm thinking of 2 in particular where churches sent a group of 15 or 20 people to, in one case it was Mexico, in one case I think it was Bolivia. And the cases were very similar in the sense that the group was in very rural areas of those countries, and the roads were very inadequate, and yet they were driving in these vehicles, these trucks. And in both cases, there was an individual in the back of the truck that was thrown out of the truck onto the ground and sustained serious back injuries. In both cases, they went to the church. They turned their medical expenses into the church, thinking the church had insurance to cover it. And the church was responsible for not providing adequate supervision. And what they found out was that, and it came as a shock in both of these cases to the church leadership, that there was a provision in their insurance policy under that exclusion section. You're beginning to see the importance of being familiar with that exclusion. So that's the third exclusion we've talked about today. And what you'll see is a very common exclusion for extraterritorial coverage. That means any injuries taking place outside of the United States, not covered. So what the argument was by these injured victims in these two unrelated cases that I've dealt with recently is the church was negligent in not telling us how little, if any, insurance they had for our foreign trip. So the church is responsible for all of our substantial injuries, tens of thousands of dollars in each of these cases, maybe over 100,000 in one. The church is responsible because they didn't tell me they didn't have coverage. I would have gotten it. So what I've suggested to churches is they have people participating on these short-term missions trips sign an assumption of risk form, whereby an adult can do this, a minor cannot. You assume the risks of that trip, and then you list the insurance coverage available. Sometimes churches will purchase, a short-term trip coverage, which is usually very minimal. But to say, this is the insurance, if any, maybe there's none, and say that. The church is not, our policy doesn't cover extraterritorial. If you want medical or health coverage, it's your responsibility. Or list what coverage the church does provide and say, if you want more, it is your responsibility. That completely negates the negligent representation argument that, well, the church didn't tell me how much insurance we had. So I think if you're sending groups of people overseas, you need to know what coverage, if any, you've got, and most of you are going to find out you don't have any under your liability policy. Can you get more? And list what that more is on an assumption of risk form, and make sure the individual knows that's up to them. It's their responsibility. If they want more coverage, fine, but it's your responsibility to get it.
So many times we have groups taking those mission trips. My daughter went to Nicaragua on a trip with a bunch of kids. And it's so easy to pick up a small policy, for like $5 per child to go on these trips, and it will take care of medical up to a certain amount and liability up to a certain amount.
And expatriation.
And expatriation, if it's an employee, they'll repatriate them back if there's an injury.
Risk, yeah.
Oh, it is. Foreign liability. I'm just going to talk. If you're taking those trips, a lot of people do not think about foreign liability. So I'm talking about liability from a general liability standpoint to protect the church if a suit is brought back into the United States, contingent auto liability, and of course repatriation. I know that I was reading last week about a case in Mexico, and where a person went to Mexico. They were smart. They bought the insurance at the Mexico border because their United States automobile insurance would not cover Mexico. So they stopped at the border. The problem was they put down one driver, and they didn't put down everybody's driver. One guy was tired. They let somebody else drive. A person actually hit him, okay? But he was not the specified driver on the insurance policy. They arrested him, and he sat in jail for 2 weeks because it wasn't his fault, but they didn't have the proper insurance. So it's real important to have the proper insurance. And if you're going to be making foreign trips, I suggest getting an international policy, which will automatically cover general liability for foreign operations, your contingent auto liability, and your repatriation coverage. Good. So Let's talk a little bit about umbrella and excess coverage.
Okay.
A lot of people say, well, I've got general liability, I've got business automobile liability, I got directors and officers, including employment practices liability. Why in the world would I need an umbrella coverage? Can you want to start with that?
Well, to be sure that you have adequate coverage. We addressed this in a previous session, but how much coverage does a church need? And of course, that's tied to the assets of the church, which need to be replaced, but also to the kinds of activities the church is engaged in. So if you're doing a lot of trips in the continental United States, missions trips, if you have a lot of programs targeting children or minors generally, the liability goes up significantly. If you have a preschool, the liability goes up. So in some cases, you need coverage beyond what the general liability policy is going to provide.
So many times people ask, what limit of liability insurance, excess liability insurance do I need? And what we normally will do is we'll look at their total assets, and are they doing hazardous things? Do they own a camp? Do they have buses where kids, a lot of kids could get hurt at one time? Do they have 15-passenger vans, which we prefer them get rid of the 15-passenger vans and switch, but there's still a lot of 15-passenger vans out there. So when we look at all of this, then we try to calculate what umbrella limit they should have. But it is not uncommon for a church now to have a $10 million umbrella limit based on their assets for a larger church. So,
and the cost is not that significant, is it?
No, it's amazing. The first million actually is expensive, but to add on those layers after that, it goes down tremendously. Mm-hmm. So if you do not have an umbrella policy, you might consider doing that. It just gives you that little extra layer of liability above and beyond your general liability, above and beyond your automobile liability. And a lot of them actually will go over your sexual misconduct coverage also. So you can buy a little bit more sexual misconduct coverage.
And I think looking at this, not so much institutionally, but individually, for you pastors or church leaders, to have an umbrella policy for yourself that adds additional coverage on top of your auto and homeowners policy, which usually can tend to, especially if you haven't updated those over the years, tend to be less than what you actually need.
Yeah, it's just a must. We had a case here the other day, speaking of pastors, where a pastor lived in a parsonage, and of course he would have people over all the time. We'll have, we're going to have the women's ministry over. We're going to have the men's ministry. We'll have kids ministry. And some of his stuff got damaged. And he was surprised, it was his personal stuff, that there was an exclusion on the church's policy that they weren't covering his personal stuff, that he needed to have his own liability policy and his own personal property policy. So you have to be careful in reading those policies. One of the other things that I have been seeing here lately, and actually we've had two cases, and of course, working for AG Financial, we see this, is a church dynamics is normally set around a pastor a lot of times. And when it is set around a pastor, if something would happen to that pastor, that puts that church where they're not going to be bringing in the same amount of funds for a while. And what we're going to talk a little bit about is key man life insurance. And the necessity of a church, if you have a loan on a church, to have a key man policy to protect a time period where you can bring in another dynamic pastor. Because actually, what happens if a pastor dies and they've got this church loan out there? It's going to take a while for them, for those funds to come back. And how many people leave that church? I can tell you that I've seen 3 instances just working with AG Financial in their loan department where churches I've had them where they do have a life policy, and I've had them where they do not have a life policy. And the angst that they go through because they don't have insurance. They don't have life insurance. You also have to be careful, though, if you're going to provide a little extra for them to give to their family. I suggest actually doing 2 separate policies because the government's looking at any way they can to collect money. And if you give yourself a benefit, whereas I'm going to give a life insurance policy to you personally for the benefit of your family, and I do not charge you taxes on that, what they could do is come back and say the benefit was not taxable, so the when we pay out the life insurance proceeds, those will be taxable, and you do not want that happening. So talk to an insurance agent that knows a little bit about life insurance and make sure that you get set up the same way. One of the other things we'll talk about, let's just talk about a church's responsibility to cooperate with the insurance company. We like this guy. This guy has been a good person. We don't really want to do anything to mess things up, so we're not going to really cooperate with the church insurance to go after this guy, or to we think we should be paying him, and the insurance company says no. Talk a little bit about what a church's obligations are to cooperate with the insurance company.
Yes, if you look at the policy, in addition to the exclusions, another very important provision of the policy are the conditions that the church, as the policyholder, has to abide by. And we talked our last presentation about the duty to notify. Very important duty. It's a condition of coverage. You must notify the insurance company not of lawsuits, but of potential claims, which may happen quite a distance before an actual lawsuit is filed. So a lawsuit is filed, you turn it over to your insurance carrier, they say, hey, there's no coverage because you didn't properly notify us of this. I talked about a case last time where there was 5 years from the time a church knew that there was a claim to the lawsuit being filed, and they turned the lawsuit over to their insurance company 5 years later, and it was denied because they didn't properly notify. And another one of these conditions is what's often called the duty to cooperate. The insurance company is not in an adversarial position. They are basically your ally, but for them to properly evaluate the claim and defend you, you have got to cooperate. They don't know what happened. And so there's a duty in your policy to cooperate with the insurance company in its investigation of the claim. Sometimes churches view that as being overly intrusive, that it may work against the benefit of one of their staff members, and so we're going to do as little as possible, or maybe we're not going to cooperate at all. That can result in the insurance company denying coverage based on your failure to abide by that condition. And the word condition is important, because what it means is it's a condition to you having coverage. And if you don't comply with that condition, there's no coverage. So it's very important for you to understand you have a duty under the policy, a contractual duty you agreed to when you signed that policy, to cooperate with the insurance company in its investigation of claims.
Let's talk a little bit about, just use that instance where you knew of an incident that happened 5 years ago. What we see a lot of times, or we get a phone call, is we have a claim that happened 5-10 years ago. We need to report that. And you go to your current carrier, well, actually, you need to report that to the carrier you had 5 or 10 years ago. A lot of churches have no idea how long that they should keep records or what records they should keep. And once they get a new insurance policy, out with the old, in with the new, and we're fine. But how many times have we seen things that happen 5, 10, 15, 20 years later, okay? And they're saying, make us whole. And I will tell you that an insurance company is going to say, you prove that you had a policy, and then we'll look at setting up a defense for you. Mm-hmm. But what kind of record retention should a church keep for their insurance records?
Well, I'm asked that question frequently. How long do we keep church records? Well, 87 months and 3 days is what I say. I mean, they're looking for a specific answer to a multitude of potential records. In fact, I have a book in my library that's 500 pages long that's entitled Federal Record Retention Requirements. Not counting state, just federal, 500 pages. So believe me, there's no answer to the question, how long do we keep church records? But there's a variety of answers to that question. In fact, I did 3 articles a few years ago for one of my newsletters on record retention requirements. I only dealt with corporate and employment and tax records, those 3 categories. And those were 3 articles with scores and scores of rules. And so, but I'll tell you this. One thing is clear, that there are some records you want to keep permanently. And as you alluded to, Jerry, that certainly includes insurance policies. Those policies, you throw those things out when you change carriers, that's horrible. Because what if you get sued for an alleged case of child abuse that took place 25 years ago? You have coverage based on the policy you had at that time if you can produce it. You can't just start calling insurance companies. Did you insure us in 1980? I mean, they're not going to respond to that. So it's your responsibility to find and present the insurance policy which defines the coverage that you've got. Those should be kept permanently.
I agree. And actually, a lot of the insurance agencies only protect themselves by carrying 7 years' worth of records. So if it's more than 7 years old, they're not going to know the insurance company or the policy number to get that protection. We once again want to thank you for tuning in to Risk Management Live. Rich, thanks for being with us, and we'll see you next time for Risk Management Live.